Before we start this morning, I wish briefly to address legal representatives. I can understand that from time to time, during the evidence, members of legal teams will wish to communicate with each other. However, even whispered conversations can be distracting for the witness. Could I ask you, therefore, so far as possible, to communicate electronically and keep spoken conversations to a minimum? I would find that very helpful. Thank you. Could we have the witness, please? Good morning, Mr. McSporran.
Good morning, my lord.
Miss Graham, carry on, please.
Thank you. Good morning, Mr. McSporran.
Morning, ma'am.
I think yesterday I was taking you through the log.
Yes.
And I intend to do the same thing today.
Yes.
We were up to decision number 12. And at the close of business yesterday, we'd moved on to talking about some of the statements that you had on
Yes.
the 6th of May 2015.
Yes.
And I'd gone through the statements of two key eyewitnesses, Ashley Wise and Kevin Nelson.
Yes.
And I'd like to go back to completing that passage of questioning, if that's
Of course.
right. So we're 6th of May. You've made it clear in your evidence, as have others, that officers are in really a unique position in that they have the legal right to use force.
Yes.
In the UK, and that includes even deadly force.
Yes.
But they have to justify that use of force.
They need to justify it. It's got to be deemed to be proportionate and necessary.
And reasonable.
Yes.
And they've to use the absolute minimum force, and they have to preclude other less forceful options.
Yes.
And that's either based on their experience or perhaps having tried it and failed to achieve
All the
the goal.
circumstances at the time.
And on the 6th of May, officers had been given the opportunity to make statements, but they had elected to not give statements on pending legal advice.
They'd been asked for statements on a number of occasions. We direct those requests through the SPOC, as we discussed yesterday.
Thank you. And you've not received any statements at that stage, so you've no basic facts, initial accounts, statements of any description.
Not from the 9 principal officers.
And not on the 6th of May.
No.
And nor had you received any use of spray forms or use of force forms.
No.
But what has been done is PIRC investigators have taken these two statements from Ashley Wise and Kevin Nelson.
Yes.
Now, when I went through them yesterday, I took out sections, a snapshot of elements of those statements. I didn't read them all out to you. But taking that again, from Ashley Wise, she had said 6 officers were surrounding the man, holding him on the ground. It looked like one officer was using a baton to hold the man down. It was on his upper chest towards his throat. Officers were lying on top of him at least 5 minutes, maybe 10 minutes. I've extracted from her statement those elements.
Yes.
And you explained that you would have been advised about that on the 6th and have had an opportunity to look at the statement.
Yes.
And Kevin Nelson's statement was the man was walking along the road, acting as if the police were not talking to him, ignoring everything being said. He didn't appear to be holding anything in either of his hands.
Yes.
And I think you mentioned yesterday the statement you had of DC Connell.
Yes.
About a knife being found at some remove from the location where the incident occurred.
Yes. From memory, I think it was 30 to 40 yards away.
So Kevin Nelson's evidence in that regard seemed to be tying in and consistent with the evidence you had, the statement you had from DC Connell.
Yes.
And Kevin Nelson went on to say, and again this is a snapshot, the man lunged at a female officer. Mr. Nelson then left his window for approximately 10 to 20 seconds as he walked out his front door into his front garden
Yes.
to his gate. He got to the front garden to have a closer look. The man was face down on the pavement with 5 or 6 male officers attempting to restrain him. One appeared to be kneeling on the ground with the weight of his upper body by use of his arms to the back of the male's shoulder or back of neck area. The other police officers appeared to be laying across the black male's body. So that's a snapshot again of Kevin Nelson's statement,
Yes.
which had been taken on the 5th of May. So we've heard evidence, and obviously you were a police officer in the past, and you will have undergone officer safety training,
Yes.
and you will have been trained in the techniques, but also received an officer safety training manual at some point.
Yes.
Going through those. We've heard evidence about the training, so I'd like to put some suggestions, propositions to you, but if you disagree, you can let me know. It may assist actually if we have the 2013 manual on the screen. Now this is the manual that was enforced, if you like, at the date of in May 2015. So if we could have page 29 of the OST manual from 2013 on the screen. It's page 29. I think it's page 23 of the manual, but it's 29 on the PDF. Here we are. What I'll do is I'll read through some of these items which are mentioned in the manual and just ask you to confirm that you recognise that
Yes.
information. So this is part of the module 1, medical conditions and considerations, and it says 2 specific medical conditions, namely positional asphyxia, restraint-related asphyxia. That's what I'm really interested in at the moment. So the officers are taught in this part of their training about a safe system and appropriate restraint techniques, and they're advised about the risks of restraint. And part of the training they're given relates to something called positional asphyxia.
Yes.
And we see on the left-hand column, if we could move down, positional asphyxia is also known as restraint-related asphyxia. And that can occur when a subject is placed in a position which interferes with the ability to breathe. Death can occur rapidly, and it may be that the case that a police officer can be found liable. Do you see that?
Yes.
You would have been aware of that as a PIRC investigator from your
Yes.
experience in the past. And the risk factors that contribute to the condition positional asphyxia can include the subject's body position results in partial or complete airway constriction, the inability to escape, the subject is prone, and that means face down.
Yes.
And at the bottom it talks about respiratory muscle fatigue related to prior violent muscular activity, such as fighting with police officers.
Yes.
My understanding is that could be struggling with police officers.
Yes.
Yes. And then moving on to the top of the right-hand column, there's also guidance here about signs and symptoms. Officers should recognise the following symptoms and be prepared to administer emergency first aid. And there it also talks about body position, restricted to prone, face down. And just further down at the bottom of that page, when a subject has been involved in a physical and violent struggle, the exertion involved causes the muscles to use oxygen at an increased rate. The process can cause oxygen debt in the muscles, and the physiological response to that is accelerated breathing. When a subject is restrained, ventilation, the process of getting air into and out of the lungs, can become more difficult due to the internal organs exerting pressure on the diaphragm. This is particularly evident when a subject is placed in the prone position or pressed against a surface. There's mention of when hands are restrained to the rear, and then the process of restraining often requires the upper body to be held down, sometimes by an officer's own body weight. This chain of events may trigger positional asphyxia. So officers are encouraged to remove the subject from the prone position as soon as possible following restraint. The subject can then breathe without restriction, and the officer can still carry out search procedures before executing the safe get-up technique. So if I can summarise my understanding of the information that's given to officers about positional asphyxia and the risks associated with positional asphyxia. Officers are taught they have to be very aware of these risks because it can cause death.
Yes.
And being in the prone position, being face down, creates a risk, a potential risk of positional asphyxia and death.
Yes, and obviously the longer it occurs, the greater the risk.
Exactly. So if they're held down for a longer period, that can cause risks. But it does say in the manual, death can occur suddenly.
Yes.
And there's no, as I understand it, there's no guidance given to officers that you can safely hold someone in this position for a certain length of time, because there's not a known safe length of time that someone can be
Yes,
held down.
and it's very much dependent on the individual themselves, because there's a number of factors, one of which is obviously age, stress, obesity, etc.
And alcohol or drug intoxication.
Yes.
These can be major risk factors as well.
Yes, alcohol intoxication can be quite obvious. Drug intoxication may not be obvious initially.
Thank you. And then, as I understand the training that's given to officers, officers that obviously sometimes a restraint has to be carried out, and officers who do perform a restraint, they should not be putting their body weight or pressure on the chest of the subject or the back of the subject.
That's the general guidance, but sometimes I would say it's unavoidable due to the nature of what's occurring. It's preferable that if it does occur, it occurs for the shortest possible period, but you do need to bring the person under control. So sometimes I would say it is unavoidable. Certainly within my time in PIRC, we have looked at these sets of circumstances, and sometimes it is unavoidable. And that's why you've got to minimise the time that it actually occurs to lessen the risk.
And officers performing a restraint should avoid restricting the neck area.
Yes.
And officers performing a restraint should minimise the amount of time that the person is restrained on the ground, and he should be put into a sitting position or a standing position as soon as possible.
Yes, particularly in the prone position. Initially, probably you move them onto their side, and then you move them into sitting up, and then eventually getting them up off the ground.
So although restraint may on occasions be unavoidable, there are protections in place to avoid the risk of harm caused by positional asphyxia.
Yes, and there's certainly guidance in that regard.
Thank you. And on the 6th of May, we know that at that stage you do not have a confirmed cause of death.
No.
You have only ruled out blunt force trauma to the head.
Yes.
So you've not ruled out positional asphyxia, restraint-related asphyxia.
No.
And you've not ruled out restraint as such.
As a contributory cause?
As a contributory cause. Now, can I ask you, when we look at the evidence that you have available from Ashley Wise and Kevin Nelson,
Yes.
which appears to, at its highest point, amount to evidence from Ashley Wise that, or a statement from Ashley Wise, that an officer was using a baton to hold the man down on his upper chest towards his throat. He was there for 5 minutes, maybe 10 minutes. Kevin Nelson talks about 5 or 6 officers attempting to restrain the man. One appeared to be kneeling on the ground with the weight of his upper body, using his arms to the back of the male's shoulder, back, or the back of his neck area. And the other officers, so that'd be 4 or 5 officers, appearing to be laying across the male's body. So you have that on the one side.
Yes.
You have a knowledge about safe restraint methods on the other.
Yes.
Where at that point would you say the investigation was going by PIRC?
What I would say is we need to wait for the results of the final post-mortem to determine whether asphyxiation was a contributory cause. And that's going to come several weeks later. So you are alive to it because you've got the statements, obviously, but you await the results of the final post-mortem because that will inevitably provide that additional information which may indicate whether asphyxia was a contributory cause.
Right. What impact does these statements from Ashley Wise and Kevin Nelson, what impact do they have on the status of the officers at that stage?
I don't think it changes the status of the officers. The officers are still considered to be witnesses. We were building the picture of the length of time of the restraint, and we were building that through obtaining witness statements from airwave radio traffic, from storm logs, etc. How long did this restraint occur? And we did break it down minute by minute, second by second, which you'll have noticed within the PIRC reports. So while Ashley Wise has said 5 to 10 minutes, what we're trying to do is build that picture through other evidence, and therefore I think the time was about just over 4 minutes, so it wasn't as lengthy as 10 minutes. So that's why you're gathering all that additional information to clarify the picture, because each witness sees things differently, and you're trying to find supporting evidence to either support what they're saying or exclude what they're saying, or not so much exclude it, but just build the picture in totality through gathering as much other evidence as possible.
When did you have evidence available to suggest that it was 4 minutes rather than 5 to 10 minutes that this?
I don't know precisely, but there will be a date that we obtained the airwave recordings, that's the police radio chatter, and the storm logs, because the officers obviously declared they were on scene, and they also radioed in that the man, Mr. Bio, no longer appeared to be breathing, so that gave us a more definitive timescale.
Right.
But I don't know when we received that, but we did receive it.
All right. We'll maybe come on to that aspect later when we look through the log. But I'm interested in the status of the officers on the 6th. When you have 2 statements, would you agree that those statements by Mr. Nelson and Ashley Wise indicate a level of force being used that may constitute an excessive use of force?
I don't think we could say that at that time. There was a struggle. We know there was a struggle. There was a struggle on the ground. We knew there was a struggle on the ground. But I think, as we said earlier, did that contribute towards the death? We were unable to say so, and the initial results of the post-mortem were unascertained. So was restraint a contributory factor? We did not know. And because we did not know, that meant that we did not change the status of the officers. They were still considered to be witnesses.
So you would have waited for the final post-mortem report before taking any view?
Yes, and all the other evidence that we gathered.
Did you consider at that point, because you had those 2 statements, changing the status of the officers?
No.
You didn't consider that?
No, for the reasons I've already given.
Well, did you consider it and decide not to change the status for the reason you gave, or did you just simply not consider it?
What we'd do is collect the evidence, and the evidence would then point to whether the status of the officer should be changed.
So you have two statements.
Yes.
And was there consideration given at that point to change the status? Ultimately, you've obviously explained you decided not to, but was consideration given on the 6th of May, in light of those two statements from Wise and Nelson, to consider whether the status of the officers should be changed?
No. For the reasons I've already given, plus the fact that the post-mortem result was unascertained, so we did not know whether the restraint contributed to the death or otherwise. Therefore, I think as we discussed yesterday, you need evidence to place this person into the suspect category, and therefore you collect that evidence and you collect as much available evidence. Now, it doesn't need to be beyond reasonable doubt, the criminal threshold, but you certainly need some evidence. Now, two people had saw the restraint. It was obviously a restraint on the ground. There was a struggle. But as we say, we wanted to know how long did that occur. Could that have contributed to the death? And that would come through pathology and other mechanisms.
Right. So at that time, you didn't consider there were reasonable grounds to suspect that the officers had engaged in any criminal activity?
That's correct.
So the status was not changed?
That's correct.
If the status of officers had been changed at that point, I appreciate you say that wasn't the position, but if their status had changed at that point, am I right in thinking immediately they would be given legal protections as suspects?
Yes, and I think we discussed that yesterday.
Yeah. And so would it then have been possible for you to interview them under caution as suspects?
Yes.
And as suspects having interview under caution, they'd have been entitled to have a solicitor present at that time and be given the caution that they didn't need to say anything if they didn't wish to do so. That wasn't done.
No. And I think, as I explained yesterday, we did not have a complete picture of what occurred, because what was lacking was the officers' accounts of what occurred, and we were piecing it together from various witnesses and other evidence. Many of the witnesses had only seen partial events, so the only people that could tell us exactly what occurred was the officers themselves, and that's why I consider them still to be witnesses, because I didn't have, in my mind, sufficient evidence to place them into the suspect category.
So you, looking forward, you obtained those statements on the 4th of June.
Yes.
You were able to review those statements at that time, maybe that day or the following day.
Yes.
So early June. And once you got those statements from the officers, so this is the first time you've seen their versions of what happened.
Yes.
So you've gathered in more information. At that point, was there an assessment or a discussion about their status?
From my memory, and you can maybe assist me here, we didn't get the final post-mortem report until after the 4th of June.
That's correct. So you didn't discuss their status at that stage, you waited for the final report?
Yes, and having obtained the exact details or the officer's account of those details, I still didn't consider that their status changed.
Right. So you considered it but didn't change their status at that point?
No.
So still took the view that there were not reasonable grounds to suspect criminal activity?
Correct.
So the final report in post-mortem came in on the 18th of June. And we've heard evidence about this. We've looked at the final report with Dr. Shearer, who's a pathologist. And it said, sudden death in a man intoxicated by MDMA, ecstasy and alpha PVP.
Yes.
Whilst being restrained.
Yes.
And so by this stage, the 18th of June, all the investigations, toxicology and such like have been completed.
Yes.
And the final report is available.
Yes.
So at that time, specifically mentioned in the cause of death is restraint.
Yes, but what it doesn't say is that restraint contributed to the death. What it says is sudden death in a man intoxicated by ecstasy and alpha PVP whilst being restrained. So it didn't say restraint contributed to the death.
So if you would have expected there's something to be said within the cause of death about the restraint other than whilst being restrained.
Yes.
So the reference to whilst being restrained was not sufficient for your purposes at that time, is that what you're saying?
No, because it doesn't say whether restraint contributed or not. It just says whilst being restrained.
And did you look into that with Dr. Shearer?
Certainly, the surprising element of it was the alpha PVP. Most people have heard of ecstasy. In 2015, when we saw alpha PVP, that was practically unheard of in the United Kingdom. And we're wondering, well, what is this drug? So we had to do quite a lot of research into that. And what our research flagged up is there have been a considerable number of deaths in America, in Florida, specifically Broward County. I think there have been a few hundred deaths where alpha PVP was a factor. So that appeared as a potential significant cause or contributory cause. But we still didn't have the fact that restraint contributed.
So you took the view that the reference to alpha PVP was a significant contributory cause?
Potentially, and therefore we needed to do our research, but also I think we needed expert evidence from medical professionals.
Why do you say potentially when it's written in the final post-mortem report?
Because I don't know, and it's from memory. So it says that sudden death in a man intoxicated by ecstasy and alpha PVP. So is it a combination of both, or is one the primary one, etc.? We needed to learn more about alpha PVP. We hadn't heard about it. We did our research in the UK. There had been no deaths up until that point where alpha PVP was recorded as being a contributory cause. There had been one overdose from memory which occurred at some music festival down in England, but it was practically unheard of, and therefore we needed to do quite a lot of research. And having done that research, we also needed to get expert opinion from medical experts.
I can understand that your own experience at that time may have been limited in relation to alpha PVP, but what you have in the final post-mortem report from Dr. Shearer and the cause of death is that there is a reference both to MDMA, ecstasy, and there is a reference to another drug called alpha PVP.
Yes.
And they had caused intoxication.
Yes.
But the cause of death was sudden death in a man intoxicated whilst being restrained.
Yes.
And you're describing the contribution of alpha PVP. Why was there no equal consideration being given to the contribution of the restraint?
Because I think in that final post-mortem report, it does not say that restraint contributed. What it simply says is he died from drug intoxication whilst being restrained. It doesn't say how much the restraint may or may not have contributed to the death.
Well, what it says is sudden death in a man intoxicated by MDMA and alpha PVP whilst being restrained.
Yes.
So restraint is mentioned as part of the cause of death.
Yes.
I'm wondering why the focus became on the alpha PVP rather than exploring in more detail the contribution of restraint.
We did consider that with medical experts later, And that's why we sought those opinions from medical experts.
Did anyone get in touch with Dr. Shearer or Dr. Buhadir?
I know William Little had regular dialogue with Dr. Shearer, particularly because at Crown's direction we sought expert medical advice, and we had to get samples from Dr. Shearer, so there was dialogue between Billy Little and Dr. Shearer, because we were taking slides and things like that and providing them to medical experts for that to enhance medical opinion.
I'm interested in whether there was a discussion with Dr. Shearer about the contribution of restraint to the death. Do you know if there was, did you have a conversation with Dr. Shearer
No.
about the contribution of restraint?
No.
As far as you're aware, did Mr. Little have a conversation with Dr. Shearer about the contribution of restraint to the death?
I don't think so, but what I have in my mind is that Dr. Shearer knew that Crown had directed us to approach further medical experts to obtain some of that additional opinion. And certainly there was engagement with Dr. Shearer by Billy Little, because we needed to obtain slides, and also to inform her that we were going to share copies of the post-mortem report with these additional medical experts.
I asked Mr. Little about material contribution. You obviously know about that. You've talked about the contribution that alpha PVP may have had on the cause of death. It'll be a matter for others, but he didn't seem to appreciate the concept of material contribution. And I'm wondering why that avenue wasn't explored with Dr. Shearer or Dr. Buhadir.
I think because, really I think you should probably direct that towards them, because
Towards who, sorry?
Dr. Shearer primarily, because what I'm thinking is we knew Mr. Bio had ecstasy, MDMA in his system, metabolised ecstasy, which is MDA, alpha PVP, and I think some steroids. You would know the levels within the blood, you know, the proportion, number of micrograms to, or millilitres to whatever. But you don't know whether those levels, or how much of those levels may have caused or contributed to death. We know, and we've seen it within the UK, that ecstasy alone has caused death when people have taken ecstasy and had an adverse reaction. Now, how much and what level does it cause? And I think that's potentially different in every person, because every person will react differently. Ecstasy is a recreational drug. People take it. I think it's well documented. It's used regularly in the UK, but there have been ecstasy deaths. But we don't know what level or what contributory level, and that was why we were going to additional medical experts.
So the situation we have is a final report with cause of death saying sudden death in a man intoxicated by ecstasy, alpha PVP, whilst being restrained. It appears from what you're saying that the focus then for the PIRC investigation became exploring what alpha PVP was and what the implications of that were.
Yes.
And you wanted to find out more about these deaths in Florida and how that contributed.
Yes, I later, I think it was 2016, I went over to America to research it. Went to the National Drugs Conference and found they were doing inputs in relation to alpha PVP deaths. So we were doing that further research. Now all of that takes a period of time, and of course we were going to medical experts in the UK for additional expert opinion in relation to, one of them was restraint. I think two of the experts were specifically tasked with looking at the contribution of restraint to Mr. Byro's death. Others were looking at the broad range of medical sort of issues within that.
So just to recap then on the, so this, we're now at the 18th of June.
Yes,
You have the final post-mortem report.
yes,
You have two statements from eyewitnesses, Ashley Wise and Kevin Nelson,
yes,
which give an indication of a restraint which may not mirror the type of training that's given to officers.
we also have the officers' accounts by that stage.
You have the officers' accounts,
Yes,
which give you much more detail about what they say they were doing and others were doing.
yes, who did what?
Who did what?
Because you had, I think, two officers at the feet applying leg restraints, so that's not direct pressure in any area. So, you know, you're building that total picture. And I think we've also got to remember that our job is to collect and present all the evidence to Crown, and let Crown decide a lot of these matters.
So I'm wondering why at that point PIRC take the statements that they have from eyewitnesses, the officers' accounts, the final post-mortem which mentions specifically restraint, and send that to the Crown and say, this is the evidence. If you want us to do any more investigation with experts, please let us know.
Yes, and we did do that. We went to Crown, and Crown said, right, obtain a range of experts. So what we did, various ways of doing that. You either go to College of Policing, National Crime Agency, and who maintain the list of experts in various fields. And you obtain a list of experts, and we then send that to Crown and say, right, here's a range of experts in the various disciplines that you want further examined. And Crown then says, well, let's say we obtain the names of 6 experts. Crown might say, well, go to 1, 2 and 4. It's for Crown to decide who we should approach.
Can I ask you what your experience of instructing experts is as a senior PIRC investigator?
I've previously sought expert opinion, not necessarily within PIRC, but certainly in relation to murder investigations I'd undertaken. Biologists, soil sample experts, you know, particularly in the early days, when you're holding forensic strategy meeting, you have a range of forensic experts there to assist your determination. Each murder scene is different, and therefore you might require different forensic analysis dependent on the nature of the scene.
What experience did you have as a senior investigating officer of instructing medical experts?
I can't recall now.
Do you remember having been in a position of having to instruct experts on the instructions of Crown as a PIRC investigator?
Yes, certainly we had, not within PIRC, but within the police, I do recall seeking expert medical opinion beyond the pathologist, just in relation to, I can't remember the specific murder inquiry, but I had sought that. I hadn't done it within PIRC.
Right. So not done it within PIRC, but you did have, was that one murder inquiry that you'd had experience?
That's the one I remember. Whether there was other ones, I can't recall now.
I'm wondering why PIRC are being expected to take this instruction of medical experts forward rather than the Crown.
Because we are investigating on behalf of Crown, and therefore Crown said we want expert medical opinion. There is a process established which says you go to the College of Policing, you go to the National Crime Agency, they maintain the list of experts. You obtain the experts, you provide their CVs to Crown, and Crown then say, right, okay, we are instructing. Also, because we have the available evidence within PIRC, we prepare what's called expert witness packages. So we put statements in, redacted statements, post-mortem report, additional evidence. We give that to Crown for their approval. So it's Crown are approving, yes, that's fine. Send that to this expert.
Right. So in terms of identifying as an appropriate expert, is that done by Crown?
We obtain a range of experts, so we are not selecting the experts. We are obtaining a range of experts, supplying their CVs to Crown, and Crown then decide which ones that we should then approach on their behalf and prepare that expert witness package, as I've said.
So in terms of identifying whether the expert has the correct qualifications, the right experience, those decisions, whether there's conflicts, those decisions are made by Crown?
Yes. I think to expand on that slightly, so we know we wanted 2 experts in restraint, so we might obtain the names of 4 to 6 experts in restraint, provide their CVs to Crown, Crown then would then say, right, approach A and B.
So was there any occasion where PIRC were selecting the appropriate expert, or was it largely exclusively the Crown?
It was always Crown who instruct us. As I say, we obtain a range of experts in particular fields, provide their details to Crown, Crown then select.
So it would be an option for Crown to say, none of these experts are suitable, go away and find someone else?
Yes, and from memory, in the investigation of the death of Mr. Byle, Crown said, we don't want you to go to this one, we want you to go to that one.
And they then send you the instruction to follow through with providing the paperwork to the expert?
Yes.
What support do you have in relation to drafting a letter of instruction to the expert?
We would draft a letter of instruction. We would show that to Crown, so Crown are aware, because each expert might be providing opinion in a particular field, so each letter of instruction would be adapted to take cognizance of that, what we wanted from that expert within that particular field, and we would show that to Crown. Crown would approve that, and that would form part of the expert witness package, so that the expert would know exactly what's been asked of them.
And what support did PIRC have to prepare the expert witness package?
We prepared it ourselves. Myself and Billy Little largely did that. Certainly, we redacted statements to take out names, so that the experts would largely not be aware of the names, so you would change the name to Officer A, Officer B, Officer C, and I did those redactions. And I think you've probably seen the redacted statements. So I personally undertook those redactions. Partly because sometimes you can read behind the redaction due to the nature of how it occurs. So we were quite cautious in doing the redactions, printing them, then photocopying them, so you can't go behind the redaction.
So the expert witness package, we've heard some evidence from Mr. Little about this, and he explained that a situation arose in relation to Ashley Wise's statement. So
yes.
She's one of the witnesses we've been discussing, that a part of her statement had been omitted when the typed version of her statement was sent.
There was a paragraph missing.
A paragraph missing regarding, I think, use of a baton. Is that right?
I can't remember, but I know there was a paragraph missing.
It contained a significant description of the events.
Yes.
And that was missing from the version that was put in the expert witness package.
Yes.
And Mr. Little explained that that was discovered by Crown, I believe.
Yes.
And then the situation was rectified. It was then sent to experts.
Yes, that caused me and PIRC considerable consternation, and it led me to getting all the other witness statements taken so far up to that point to be checked to ensure accuracy.
Right. Do you have a up until your retirement, did you have a situation in place where that could be avoided in the future?
Certainly, we tightened up on the proofreading of statements, so statements are obviously written unless they're provided to us in a typed format, Microsoft Word or whatever format. So the admin people would then type that up, but there was obligation on the investigators or the deputy senior investigators to check the typed version against the manuscript version to make sure that there are no omissions.
So the same investigator who takes the statement will check the typed version?
Yes.
And is there anything to guard against a situation where something is missed by that person?
No, because that's a huge ask. I think we've got to understand that we're getting, well, the year before I retired, 900 referrals. We were getting thousands of statements. If you want a proofread section to do all that independently, that's a significant funding issue, and we certainly didn't have the money.
Right. When the corrections were made in relation to Ashley Wise's statement, the typed version,
Yes.
was that corrected version then resent to all the experts?
I think so. I can't really remember, but I know it didn't change their opinion, so...
Had they already prepared opinions by that time?
Yes, some of them had, and I think that's why we went back to them and say, well, does this change your opinion? I can't remember the precise details now,
Right.
but I've got a feeling that's what we did.
Did a copy of that statement go to Dr. Shearer?
No, because we don't submit the statements to the pathologists.
Thank you.
Certainly, Crown, who deal with the pathologists, could, if they had wanted to, go back to Dr. Shearer.
So you've prepared the expert package. You've sent that off to the experts. Some have prepared opinions. All of them get the new Ashley Wise statement, or the corrected version.
Yes.
And are given the opportunity to look at that and comment further.
Yes.
Was there consideration when those opinions came back as to the status of the officers?
I don't think it changed the status of the officers because none of the expert opinion, and I'm working from memory now, said that restraint played a significant role in the death. You have the expert witness opinion, so I'm working from memory.
And we've heard evidence from a number of the experts.
Yes.
When you say significant, what do you mean? A significant contribution to the death?
Yes. Well, there was two of the experts who we were specifically asking in relation to restraint, and in their opinion, I can't remember which witness it was, he considered the restraint to be proportionate. You'll have the exact details. So
I'm interested in the words you used a moment ago. It didn't play a significant, it wasn't a significant contribution to the death. Was it your understanding that it would have been necessary for restraint to be a significant contribution to death?
To change the status of the officers, I would think so. We know that restraint occurred. But how much contribution did that cause to the death? I don't think we had that, and that was why we didn't change the status of the officers. I think also we were reporting all these matters to Crown, so if Crown considered this, Crown could have changed the status of the officers and instructed us to treat them as suspects. I think we've also got to remember, and I've mentioned it in my Rule 8 statement, that having submitted all the evidence to Crown, including the PIRC reports, the then Lord Advocate James Wolfe, having considered all these matters, considered there was insufficient evidence to charge the officers.
Can I ask you if you understand material contribution in terms of the cause of death? You're comfortable with that concept?
Yes.
Are you comfortable with the idea that a material contribution is something that is not de minimis or not
Yes.
at that level? Did you understand that to play a material contribution in the cause of death, it does not have to be a significant contribution in the sense of large or more than 50%?
Yes. I mean, probably my description of significant, what I meant was material.
Right.
You know, how much did that contribute? And that's a difficult thing in a lot of instances. So how much did restraint contribute to the death? I don't think we ever got round to that. We know he was restrained. That's unequivocal. But how much did it contribute to the death? And I don't think we ever got that from any of the experts selected. I know you instructed additional experts, but we didn't have it. And certainly having presented that evidence to Crown, I don't think it changed.
So am I right in understanding you didn't think you had evidence that would support there being a material contribution insofar as we're talking about restraint? There was no material contribution to the death?
We know restraint occurred. But how much that contributed, we didn't have that. And again, you know, our default position is we report all these circumstances to Crown. It's for Crown to decide. I didn't think it changed the status of the officers, but equally, Crown could decide otherwise. And because we act under direction from Crown, it's for them to largely decide. They are, for want of a better expression, the safety net. So we're reporting all the circumstances to Crown. If Crown had considered that the status of the officers should be changed, they would have notified us, which didn't occur. And then, having reported all the circumstances, I said, the Lord Advocate at the time decided no prosecution.
Right, so you didn't, in PIRC, you didn't take the view that you had passed the threshold of a material restraint playing a material contribution in the death?
No.
And didn't change the status and sent it to Crown for them to consider?
Yes.
If you had taken the view that restraint had a material contribution to the death, if you had been satisfied that restraint played a material contribution in the death, would that have changed the way you approached things at that stage?
I think we would have sought guidance from Crown, that we would approach Crown first, notify them of all the circumstances, all the evidence we had collected, and sought guidance. Because we're then about to change the status of 6 principal officers, and therefore we would certainly go to Crown for their decision before we did so.
So was there a reluctance to change the status of 6 police officers, or a hesitation to do that unless perhaps you were on sure ground on material contribution?
There's no reluctance. You go where the evidence is. I have certainly changed the status of officers previously who have been involved in restraint, from initially it being a serious incident involving the police, involving serious injury, and having collected evidence, I have changed the status of those officers to suspects and ended up charging them. So there's no hesitation, but I go where the evidence goes.
What was it in those cases where you did change the status of officers to suspect? What was it? What was the evidence about restraint that you had in those cases that caused you to change the
There's
status?
clear, unequivocal evidence pointing towards assault.
And what can you explain to people listening what clear, unequivocal evidence relating to assault looks like?
So initially what we had was an account from the officers in relation to a serious injury. Now, having done investigation, we uncovered CCTV. This has happened on more than one occasion. We uncovered CCTV that clearly disproved the officer's account and clearly shows assault. Consequently, we changed the officer's status immediately to suspects. We notify Crown that because we need a Crown instruction to then investigate the criminal action. But there was clear and unequivocal evidence, that's what I mean.
So, clear, unequivocal evidence being CCTV disproving the officer's version of what happened.
Yes, and other witness testimony. As you work through the investigation, you gather additional witness testimony. So you put everything together, and that changed the status of the officers in more than one investigation we've done.
But in relation to the death of Mr. Bio, you had the evidence of Ashley Wise or the statements of Ashley Wise and Kevin Nelson. You had some Snapchat footage from Ashley Wise's phone. You had some CCTV footage. Am I right in understanding and evidence that you didn't consider that to be clear, unequivocal evidence that disproved the officers' versions?
Additionally, we had shared that information with Crown and no instruction came back to change the status of the officers. And I think in such a high-profile investigation, as I said, Crown are acting as our safety net here. We're investigating on their behalf, and certainly we would need an instruction from Crown to undertake a criminal investigation, and no such instruction was forthcoming.
I think we looked at yesterday at the if during the process of, I think it was in the witness interview strategy, if there was actually we looked at that with Mr. Little, if there is information that comes out during the process of the officers' statements that they're giving, if it reaches a stage where it looks like there may be criminality, then PIRC would withdraw at that stage.
Yes,
Is that right?
what we would do is halt the interview, administer the caution. They've got the full protections of law. Additionally, we would have to go to Crown and say, we have come across this, we now need an instruction. We cannot start a criminal investigation without a Crown instruction, which is very different from the way the police operate, because the police, crimes get reported to police, police investigate, and then report to Crown. We need that instruction from Crown first.
Can I take you back to the 6th of May, when you've considered the Ashley Wise and Kevin Nelson statements? Was there any point, having considered those statements, that you considered going to the Crown and saying, we've got these statements, we don't yet have cause of death, but this should perhaps be moved to a criminal investigation?
No. We wanted to collect further evidence as much as possible to clarify exactly what had occurred, and certainly we were providing briefing papers to Crown saying this is where we've got to so far, here's what we've found out so far. So we're keeping Crown up to date with the progress of the investigation, and there was significant dialogue between ourselves and Crown throughout the course of the investigation.
All right. Thank you. Can we move on back to the policy file, please? I think we just finished decision 12. I'd like to move on to 13. And decision 13 is again on the 7th of May, which is the day after you've had your, I think you said you'd gone out to speak to Mr. Hardy on the 6th of May.
Yes.
You'd left the office, and then this is 7th of May, you're back in the office, and you're talking about house-to-house strategy.
Yes.
And if we look at the reason, I think by this stage, Crown have instructed PIRC to take over the entire investigation, and there's the house-to-house is part of that. Police have handed over what they have done on house-to-house, and PIRC are taking over.
Yes.
And I think we heard from Mr. Little and yourself that the case handling staff were coming in to assist.
Yeah, and I think by that stage we knew the route that Mr. Bayo had taken from his home in Arden Crescent towards Hayfield Road, because various witnesses had seen him en route. Consequently, that's why I recorded exactly what streets or roads or whatever we wanted the house-to-house strategy, because that was the route taken, and was anybody within those houses that had seen Mr. Bayo en route to Hayfield Road.
Can I just be clear on one point in the reason? You're saying identify any witnesses who may have seen deceased from when he left his house to the point of engagement with police.
Yes.
But there was a recognition you'd want witnesses at Hayfield Road also.
Yes.
Thank you. And then let's move on to 14, please. There's then a review of Police Scotland's house-to-house strategy. I think you mentioned that yesterday, that you would review what the police had done. Was that to make sure you were happy with?
Yes, because up until that point there'd obviously been what we termed a parallel investigation. We had parts of it, Police Scotland had parts of it, so we are taking over the totality.
Can we look at decision 15, please? This is headed up, so this is dated again the 7th of May, headed up media strategy. That's something you've mentioned
Yes.
already. PIRC will produce a media strategy to inform the public and media outlets of their role in undertaking an independent investigation of the instructions on the instructions of Crown Office. And it will also encompass appeals for information and utilise social networks. PIRC media staff are to lead and advise on media. And then the reason is given public information and reassurance, allow media aspects to maximise potential witnesses to the incident. Now, again here, there's no media strategy actually attached to the log. What were your expectations in terms of who was going to draft the media strategy?
That would be done by our media team, and they would manage that aspect of it. So I'm saying we need a media strategy. You are the experts. Draft a media strategy and then manage that.
And then would this decision be actioned by tasking members of staff in their media, in your PIRC media strategy or department, I should say?
Well, you would sit down with them, because this was an exceptionally high-profile matter, attracting a lot of media attention. So we knew that we were going to get queries, questions, etc. So you would sit down, because they would already be seeing commentary in the media. So you're sitting down and you're explaining, look, you need to manage this. You are the experts. You have the communications, the contacts within the media. So you're very much saying, as I've said, you are the experts. You manage this on behalf of this investigation.
We've heard some evidence about, from the family in particular, about could I describe it as the media storm? There was a lot of media interest.
Certainly.
It was very high profile.
Yes.
And there were, over time, apparent conflicts between different organisations and people involved in this matter.
Yes.
So, on the one hand, there was the significant media interest, and obviously, in terms of Article 2, there's a conscious awareness that public scrutiny is an important aspect
Yes.
of providing an Article 2 compliant investigation.
Yes.
And on the other hand, there is a grieving family who
Yes.
are obviously very interested in what's happening in the investigation.
Yes.
And because of the difficulties with flow that may be part of the source of their information as things are going on.
Yes, I think we've got to remember that the floors are the ones that primarily are, should lead in providing information to the family. What they are not doing is providing detailed information about the investigation. That never happens. So you do not give them chapter and verse on what we've done so far. You provide them with what might be considered relevant information to keep them informed, but you don't provide all the details within an inquiry to the family, and that never occurs. But equally, particularly within PIRC, when we're doing a death investigation, you appoint your flows. We notify Crown of who the flows are, so they know what information we can impart. I think we've also got to remember, if you look at the legislation, and from memory I think it's section 44(6) of the 2006 Act, it says that we shouldn't be imparting information without the permission of Crown. Although Crown know that our flows will impart a certain amount of information, but it's quite restricted how much we pass without their express permission, and that's within law. So you're leaving it to the flows to do that. Normally at the end of a death investigation, we've submitted a report to Crown. Crown will have considered that, and at that point our flows will then hand over support to the family via victim information and advice within Crown.
Right, so you were aware that the family were upset and there's an issue with the flow. They would be interested in media coverage
Yes.
of the situation. We've heard evidence that the family instructed Mr. Anwar, who has a high media profile himself.
Yes.
The SPF, the Federation, we've heard that they would be defending their members, police officers, if the public were calling for suspension of those officers. And then we've also heard that the officers themselves had instructed lawyers, and at that time, I think it was initially, at least, it was Mr. Watson.
Yes.
So there's a significant media interest, and there are a number of different interested bodies or individuals.
Yes.
Would the media strategy for PIRC take account of all of that and the potential perhaps of the interests of different people involved, and what happens if there is a conflict or a situation that arises where issues start to develop, and the impact that that could have on your investigation?
There's various aspects to your question there. Firstly, during the course of a death investigation or a criminal investigation, you keep the information that you provide to the media as limited as possible. We know there's significant attention, they want commentary, but you're not playing out the specifics of your investigation in the media. We are not there to referee between the opposing factions, if you could call it that. And it's a significant challenge, and you get it whether you're running murder inquiries, other major inquiries, death inquiries, particularly high-profile ones. There's always a demand from the media for information, commentary, etc. One other aspect that I think a lot of people ignore is the contamination of witness memories, particularly if we've not got to them yet, or we're having to go back to them. They're reading stuff in the media, competing accounts or whatever, and that can potentially contaminate their memory of events. Having read things and then thought, well, is this what I actually saw, or are they getting what you could call false memory? There is a term, false memory syndrome. And that's why you'd rather these things are not played out in the media, because it can contaminate witnesses' memory. I'm not saying it does, but it can occur.
So from the PIRC perspective, in terms of your investigation, securing best evidence, keeping it as uncontaminated as possible, is it the case that the less is said in the media, the better?
Yes.
From that perspective?
Yes.
Does the media strategy encompass looking at what happens when things go wrong?
You don't start out from the point of view that we think things are going to go wrong. No. So I don't think that's initially planned for. I think in this instance there was significant opposing factions, if I could use that term, playing out their accounts within the media. We're limited in what we can say, and we certainly aren't going to pass comment on what the factions are saying, because we're quite restricted, as in the case with all significant investigations. You are quite restricted in what you say. You certainly wouldn't come out and say, no, that's wrong. You would rather not comment. If you're going to put something out, it's usually factual. And I think, as we discussed yesterday in your conversation with Mr. Little, was if we're going to put something out in the media, we're running it by Crown first to make sure that Crown are comfortable with what we're going to say.
Right. We understand, and from statements available to the chair, and also from, I think, Mr. Little's evidence, that in this particular case, PIRC actually did put something out into the media at one point to respond to what they viewed as inaccurate reports about PIRC's failure to secure statements.
Yes.
And if you watch the evidence of Mr. Little, you will have seen me going through some questions in regard to comments made by the Police Federation and their lawyer, Mr. Watson.
Yes.
Why was it in this case that PIRC decided to put something out?
Because I think that was, firstly, organisationally, if you are getting criticised, usually you do not respond unless the criticism is obviously erroneous. Consequently, you would be correcting something that's obviously erroneous. Normally you don't respond, but in a high-profile matter where we are subject to severe criticism, and that criticism potentially is inaccurate or wildly inaccurate, you may have to correct that. The normal course is you run anything by Crown.
Was that done here?
I can't remember.
If you could just give me a moment. I wonder if that might be an appropriate moment to...
Very well. We'll take a 20-minute break at this point. Ms Graham.
Thank you very much. We were looking at the log, and I wonder if we can go on to the next section, decision number 16.
Excuse me, ma'am, before we move on, could I just address a further issues surrounding media with you?
Oh yes, of course, sir.
All media releases must be approved by the Commissioner, and she approves them. Largely, she decides what goes in the media, what doesn't. So you may want to explore that topic further with Ms Frame. She gives her evidence.
Thank you. We do hope to hear from Ms Frame at some stage.
Yes.
Thank you. So 16 related to notification of the Sierra Leone High Commission of the death of Mr Bayo.
Yes.
And at this section in your log, you've inserted a letter that was sent to the High Commission.
Yes.
On the 8th of May, and that matter was sent out. And then at decision number, I don't want to go into that in any detail, decision number 17, it says obtain medical history of deceased. It describes obtaining GP medical records, obtaining information from the family of the deceased on any medical conditions from childhood, time in Sierra Leone or England that may not be recorded in the GP records.
Yes.
And we've heard from Mr Little that the GP records, they weren't available at the post-mortem, but they were subsequently obtained, or I think Pat Campbell was asked to obtain.
Yes, normally you try and obtain hospital records and GP records to provide to the pathologist before the post-mortem begins, just in case there were any underlying medical conditions. And it's primarily for that reason, but at that time we didn't have them.
And so this is it. The entry in the log is dated the 9th of May. Although they weren't available for the post-mortem, they were subsequently obtained, and they were to be provided to the pathologist at some point.
Yes.
And then decision 18, it refers to, this is again dated the 9th of May. It mentions a letter of notification to the Deputy Chief Constable of the PIRC investigation and the requirement to submit statements, documents and other material. Now, we heard from Mr Little about this, and he said a letter goes out very quickly, high level, explaining what you're looking for, so they can make progress straight away.
Yes, it's a legal requirement that we provide that notification. I think it's sections, in relation to Crown, it's section 44(1) of the 2006 Act. In relation to police referred, it's 44(2).
And you've included a copy of the letter to this part of the log, and we can see that in fact it's to the Deputy Chief Constable. It's the 5th of May 2015 that this was sent, and it's copied to DCI Keith Hardy, who is the single point of contact.
Yes. And
the letter is a detailed letter of 3 pages in length. It describes the involvement of PIRC. It mentions the 4th of May that Mr Little was lead investigator, and a meeting was held and there was going to be an independent investigation. And if we can look onto the second page of the letter, there's the formal notification in terms of Regulation 5 about the investigation by PIRC, and then there is a list of different items which specifies things that PIRC were looking for to further their investigation.
Yes.
And that includes the, and I'll just pick out 1 or 2 as an examples. Number 3, original signed statements from every police officer and member of police staff, including ACR staff, and statements from SPA staff who were involved in the incident, and any police officers or members of staff who undertook any subsequent actions in respect of this incident. And that should include any officer who seized productions.
Yes.
And 5 is operational statements from the officers involved in the arrest of Mr Bayo.
Yes.
And then there's also requests at 9 and 10 for things like telephone call recordings, airwave radio traffic recordings, CCTV at 11, and other records in relation to the databases.
Yes.
Going on to the next page, we also see that there's a request for images from mobile phones and copies of Police Scotland strategies, including, this is at number 16, including forensic strategy, house-to-house and CCTV strategies.
Yes.
And records in relation to PAVR CS sprays.
Yes.
Thank you. And at 21, a request that as Police Scotland have expertise in the monitoring of social networks and have directed staff to monitor such networks for relevant material, I would be obliged if you could ask your staff to continue to undertake this function, supplying such material to PIRC investigators.
Yes. And I think as
you
we've heard,
explained
we
that.
don't have a cyber capability, so we would task that to Police Scotland.
All right, thank you. Then move on to decision number 19. This is dated the 9th of May, and it indicates the lead investigator, and that was you by this stage,
Yes.
and the PIRC senior investigator to meet with family lawyer and PIRC flows and explain the role and address or answer any questions or concerns. Was that a meeting that had taken place prior to this entry being made?
I think that meeting occurred on the 6th, and as I said yesterday, the 6th I was engaged in meetings practically all day, so I'm maybe retrospectively creating these entries, because certainly we met with Mr Anwar and the family at his offices at Carlton Place, or his then offices in Carlton Place, late morning I think, potentially around lunchtime, and then in the afternoon I travelled through to Kirkcaldy to meet with DCI Hardy.
Thank you. That's helpful. Can we look at decision number 20? This relates to community impact and tensions. And community impact is being examined by Police Scotland, who will have responsibility for dealing with any issues arising. And PIRC will direct any information which may have a bearing on community impact or tensions to Police Scotland. Can I ask you about this from the perspective of Article 2 and independence?
Yes.
Are you comfortable with Police Scotland being responsible for community impact and tensions?
Well, they've got to be, the police have got to be, because PIRC, particularly when you say community impact and tensions, you know, we've seen it before where you get violence and disorder, and I'm not saying this was going to occur in this instance, but you've got to rely on the police being aware of these matters, because it is the police that deal with it. PIRC are certainly not positioned to do so. Down in England and Wales, the IOPC are not in a position to do so. So if you become aware of these matters, you flag them up to Police Scotland, just in case something may occur.
But this aspect is not part of PIRC's role.
No.
Can we move on to decision number 21, please? And this is about cultural and religious issues. PIRC flows will establish the religion and sect of the deceased and any cultural issues, seeking support where necessary from ScotGov lay advisors, in order to provide appropriate support, advice and assistance to family of deceased. Although not directed by Crown Office at this stage, take cognizance of any issue of race if they emerge.
Yes.
And then it goes on to give the reason, provide appropriate support, taking cognizance of cultural and religious issues, address family concerns in a supportive and sympathetic manner. So I'd like to ask you about this in some detail. In relation to this entry, which is the 9th of May, made on the 9th of May, is this focused with PIRC's dealings with the family?
Primarily.
Not an active line of investigation into race?
No, that's why I'm saying take cognizance of any issues of race if they emerge. Now we know subsequently the allegations were made, but that was much later. And then eventually we got the Crown direction to investigate issues of race, and I think that occurred in late August from memory.
We'll come on to that.
Yeah.
So I think by this stage, on the 9th of May, when the entry's made in the log, there's been a meeting with the family, flows have been involved to some extent, there's been a breakdown.
Yes.
So was this written against that background? I'm wondering what view you had at that time about PIRC's liaison with the family.
I don't think the relationship had entirely broken down at that stage.
Right.
We know later on there were issues, and I think probably Mr. Lewis is best placed to answer that in respect of the flow perspective. But at that stage it was still quite early in the investigation, so I don't think that the relationship had entirely broken down.
Right, thank you. Can I ask you about the use of the word sect here? What does that mean to you?
Well, we know within various cultures there can be different sects. Mr. Bai was a Muslim, so you've got Shia Sunni. That's what I mean by sect. So it's a catch-all term, so I'm putting that in. So what religion was he and what sect was he?
Right. Can I ask about this phrase about taking cognizance of any issue of race if they emerge?
Yes.
As I understand the position at this time, so this is entries 9th of May, there are no terms of reference from Crown instructing an investigation into the implications of race or discrimination.
That's correct.
So at that stage, did PIRC have the authority from Crown to investigate or adopt an proactive line of investigation regarding race?
No, and that's why I'm saying take cognizance of them if they emerge. If they emerged, I would then go back to Crown.
And can I ask you about in terms of taking cognizance of the issue of race, how would that look? Although you've written that there, how would that look in terms of the work of the PIRC investigators?
Well, I think as we gather the evidence, if those issues arose, then we would go back to Crown. I think we've also got to remember that there is European court decisions in relation to this. I think it's Nakova versus Bulgaria in 2014 that flagged up you should take cognizance of these issues. Now, whether they actually have a bearing is a different matter, but you've got to take cognizance of them.
And in terms of going back to the Crown, if something emerges and PIRC go back to Crown, what would that going back to Crown
Well, you
be for?
provide them with the evidence or the information and let them decide what they wish to instruct.
So it would then be an option for the Crown to issue an instruction
Yes,
if they elected to do that,
yes,
or to say we don't want to issue an instruction.
yes.
And right, so it would be for PIRC to take cognizance of any issues that emerge and then follow that through with the Crown and seek an instruction if that's appropriate.
Yes, and equally, it would apply to other issues, not just race, that if we come across stuff that didn't fall within our initial terms of reference, you would go back to Crown and say, look, we've discovered this, and seek an additional instruction or an amendment to the terms of reference.
All right, thank you. You've seen me ask Mr. Little questions, and you'll remember that I asked him about the analysis of language used in statements that were available to
I
PIRC.
saw that.
And I particularly asked him, for example, about the statement that was given by Kayleigh Good, PC
Yes.
Good, on the 4th of June.
Yes,
And she used the word coloured.
yes,
And she said on page 7 of her statement, I was also thinking at that point of the Lee Rigby incident in London, mainly due to the fact of the coloured male and the potential terrorist connotations. So on the face of it, she's making a connection there between Mr. Bio being black and, as she puts it, potential terrorist connotations.
I don't think it's appropriate use of language, the term coloured.
No, I've certainly asked Ms Good about this, and she's given us her evidence on that. But you obviously recognise it as an inappropriate use of language. That was a statement that was given to PIRC on the 4th of June.
Yes.
Would you classify this as something that is emerging in relation to race?
Certainly, when we interviewed the officers, all the officers, the 9 principal officers, I wanted to know what was their mindset as they were going towards this incident, because obviously they've been provided with what's happening, but I wanted to know what was in their mindset. It's quite unusual that at 7 o'clock on a Sunday morning in Kirkcaldy that a person may be running or walking about the streets with a large knife. We know that the threat level of attacks on police officers had been raised to severe shortly before the incident. So I wanted to know what was in their mindset. And some of the officers, and you'll have read the statements, well, the one that we're mentioning there, they're saying, well, I considered the Lee Rigby incident. Other officers didn't make such an association, but I did want to know what was in their mindset, because that could have influenced how they approached the incident. So we got that detail, and you'll have seen within the PIRC reports I create an entire section where I outline exactly what was in each officer's mindset as they were in considerations as they were approaching this incident.
Having considered what was said by the officers and recognising this use of language was inappropriate,
Yes.
did you reflect at that time, taking cognisance of any issue of race as they emerge, what steps should be taken in relation to this reference?
Again, it's a difficult one, and it's more to do with legislation, because PIRC cannot investigate issues of conduct in relation to federated or superintendent ranks, only ACC and above. Consequently, use of that language may be considered a conduct matter, but we have no legislative authority to pursue it.
So leaving aside conduct or disciplinary or misconduct proceedings that may be within the purview of the police.
Yes.
However, PIRC have said in Decision 21, you have written that you're going to take cognizance of any issue of race as they emerge.
Yes.
And that's any issue of race. And Mr. Little gave evidence that you were being mindful, or you were keeping an open mind about race at that stage.
Yes.
It's not part of your terms of reference. But here you have a statement from one of the officers who was at Hayfield Road commenting on Mr. Bio being coloured,
Yes.
and making a possible a potential terrorist connotation, apparently making a connection there.
Yes.
Was
I would
that
say
not
it was
one
the,
of
I
the-
would say it was the officer's consideration as to what potentially was this. So we wanted to know what was in their mindset.
Right. So you want to know what's in their mindset. This is relevant to that aspect.
Yeah.
Was this viewed as relevant to the race aspect that you were keeping an open mind about?
I don't think definitively at the time that we obtained the statement, but obviously we were providing the information to Crown to allow them to then take a decision whether to instruct. And they did.
Did you tell Crown after the 4th of June about the comments made in statements? I mean, I've mentioned Kayleigh Good's statement, but as you recall, I spoke to Mr. Little about a number of other statements also, including PC Short describing him as being deranged with superhuman strength, and talking about a wee Pakistani doctor, and talking about a comment by Acting Police Sergeant Maxwell in his statement of the same date of a black coloured male. Do you remember me asking those questions?
Yes, we would provide that information to Crown because we need a Crown instruction to specifically investigate those matters.
When did you provide information to the Crown about those comments that were made in the statements?
I can't recall, but I think it would form part of Crown's decision to then instruct us to investigate, which did occur.
Right. At a later stage?
Yes.
Did anyone in PIRC analyse the statements from the perspective of race at that time, or would that have been considered a more active line of investigation, which wasn't part of your terms of reference?
I think in June we were still heavily involved in collecting all available evidence and information. Then you would analyse it as you've got that, provide briefings to Crown, provide the information to Crown. And I know it sounds, well, it's just 1 month into, well, it's already 1 month into the investigation, but we're still heavily involved in tracing witnesses, obtaining evidence. So once you've got a lot of that, then you're undertaking that analysis and passing it to Crown. So I think as we discussed yesterday, back in 2015, we had limited resources, which delayed some aspects of the investigation, so we're still heavily involved in collecting all the available evidence with the intention of providing it to Crown.
So at the point the officers gave statements 4th of June, there was no analysis carried out from that perspective at that point?
Not at that point. I was mainly focused, well, principally you're focused on what is the officer's account of what occurred, but also wanted to know what was in their minds as they were attending this incident, what was their thought processes, because their thought processes would obviously inform how they reacted. So that was the principal focus, what actually occurred, because we're still, up to that point, don't have specific information. We're piecing it together, as we discussed yesterday, from various witnesses who had partially saw events, from airwave, from storm logs, CCTV, etc. But up until that point, we didn't have the precise details of what the officers did. We needed those officers' account, and as I said, we wanted to know what was their mindset. Would that affect how they dealt with the incident?
Can I ask you, in relation to the instruction from Crown to investigate the death,
Yes.
does that incorporate consideration of questions of race?
Crown,
That simple instruction to investigate the death?
Crown provide us with terms of reference, and we act in accordance with those terms of reference. If we discover matters, we go back to Crown and they may add additional terms of reference or expand the nature of the investigation, but we operate to the terms of reference as given at that time. And we know that at various points during the investigation, Crown did instruct additional terms of reference and set additional terms of reference and expand the investigation. And I know you went through a lot of those aspects with Mr. Little.
Yes. And we'll come on to that. So, in a situation where you're investigating a death for PIRC, if there is some overt expression of racism as part of your investigation, what would PIRC do at that stage? If they've simply been told, investigate the death, you appreciate that there is some perhaps overt or very obvious expression
Yes.
of involving racial discrimination, what would the actions be that PIRC would take then?
You would go back to Crown, you would notify Crown, and I think I gave the example earlier of there was one specific instance where it was a serious injury following police contact. The boy, and it was it's a youth, he was originally from Pakistan, and as we progressed the investigation, we interviewed him, and he made allegations that inappropriate comments had been made. But also we'd obtained other CCTV and other evidence, so we went back to Crown, and that switched from a serious injury investigation into a criminal investigation, which also encompasses the issue of race.
So at the stage of obtaining officers' statements, PIRC didn't go back to Crown at that point in light of the comments made in the statements.
No.
PIRC went back to Crown at a later date after the terms of reference were expanded by the Crown.
Well, I think we had provided briefing papers and potentially officer statements to Crown, and they expanded that, which I think was, as I said earlier, late August, but you'll inform me.
We'll come on to that. And at that point, there was no attempt to go back to the officers to explore these issues further, or issues of race?
Not at that point.
So in terms of the phrase, take cognizance of any issue of race if they emerge, that was primarily focusing on issues that might have arisen out of the investigation.
Yes. Collect the evidence, examine the evidence, and present it to Crown.
Can we move on to the next decision number, please? This is dated the 9th of May. Notification to Police Scotland to approach the 9 officers involved in arrest and request statements from them. If they decline, obtain reason for not providing statements. Tell me what was happening in relation to this entry.
I think we've already discussed that, which was I had approached DCI Hardy on the 6th and said, I want you to individually approach each of the officers, confirm their status, and tell them they are witnesses, I consider them to be witnesses, request a statement and obtain their position. And this is just backing that up.
So it's an entry made on the 9th, but is in connection with the decisions you made on the 6th and spoke to Mr. DCI Hardy about, and then I think we looked at his statement yesterday about speaking
and
to the
obviously
officers
because we're engaged in a lot of meetings and a lot of information is coming in, you're examining all that. So sometimes you're retrospectively creating these entries just to reflect what had occurred.
And if we move on to 23, again on the 9th of May, this is about police post-incident management processes, and you describe that again. Is this a retrospective entry in the log regarding interest you have in the PIP process?
Yes.
And was this work that was already effectively ongoing, but the decision is being recorded on the 9th of May?
Yes.
And then we can see at 24, it's about hospital management. 25, it's about scene revisited on the 10th of May, or to be visited on the 10th of May.
I think we spoke about that yesterday.
Yeah, these are all entries on the 9th of May, but really so bringing your log up to date.
Yes, I'm playing catch up really.
And again, 26, officers refused to give statements. Notification from Police Scotland that the 9 officers have refused at this time to give statements following advice from their lawyer. And then it says date 7th of May, although the entry is the 9th of May.
Yes, because as we know and we've discussed, DCI Hardy sent me the email on the 7th of May in respect of 6 of the officers, and then he still had to see 3. So this is me really just retrospectively recording this.
Thank you. And then 27, prioritisation of actions. Again, an entry on the 9th of May. And this looks at the PIRC inquiry managers will consider prioritisation of actions. Was there pressure on resources at this point?
Yes, and that's why we're prioritising, you know, what's the key things that we need to achieve as quickly as possible. We can't do everything with the limited resources, so you prioritise.
Then the next entry at 28 is dated the 13th of May. So between the 9th and the 13th of May, there are no entries in the log. I wonder if I can ask you to look at a letter dated the 11th of May.
Yes.
It's from the Crown Office. It's COPFS 02833A. So this is dated the 11th of May. It's a letter from the Crown to the Commissioner. And it talks about, in the first line, a letter has been received by Crown Office from the solicitor acting for the family of the deceased. It mentions matters relating to the death. I've been able to advise the solicitors no police casualty surgeon was in attendance and no photographs were taken of the body of the deceased at the scene of death by the authorities. Is it customary to have a police casualty surgeon in attendance?
Sometimes it's very situation dependent. Sometimes paramedics will provide the pronounced life extinct. Sometimes it can be a police surgeon. On other occasions it can be a GP or other doctor. It's situation dependent, and it's also dependent on their availability.
And then there's, as we move down the page, it says, do you see just 3 lines from the bottom? I would highlight the following questions that have been raised by the solicitor.
Yes.
See the main paragraph? In order that these can be covered in your investigations and so that there can be ongoing discussions with the Crown regarding appropriate disclosure. So this seems to have arisen out of some sort of discussion with the family's solicitor. And there's a request for a detailed narrative of events immediately preceding the death. The past medical history of the deceased should be fully looked into. And that seems to have been something that was already noted in the log, dated the 9th of May.
Yes.
And there's an issue there for PIRC to look into, particularly any known familial or personal blood conditions, particularly such conditions as associated with blood hemoglobin abnormalities, hemoglobinopathies such as sickle cell disease and thalassemia, and also any past respiratory problems such as asthma.
Yes.
And I think we looked at the entries for the 9th of May and saw that you were looking into the past medical history.
And some of that, a lot of that you may obtain once you get the GP medical records.
And then any history of mental health problems and questions about tablets. So, and then the questions go on to the following page. So there's quite a detailed list of bullet points involving issues that the family have raised via their solicitor.
Yes. I think what Mr McGowan is seeking there is confirmation that we are taking these matters into account during the course of our investigation. So we're not ignoring these matters, we are collecting that evidence, and really what he's doing is seeking reassurance that we are taking cognizance of these matters.
So there's nothing in the log that says another letter of instructions being obtained and giving a copy. This letter isn't in the log.
Yeah.
Were you happy this was not a formal letter of instruction in the sense
No,
of
because
others?
these are not terms of reference. This is him seeking assurance that we are taking cognizance of these matters. So he's not expanding, in my mind, the terms of reference, because we are investigating the death and all the precursor events, and he's just seeking reassurance that these matters would be taken cognizance of.
Thank you. Then let's move on to 28. And this is dated the 13th of May. Oh, sorry, back to the log, sorry. So this is decision number 28, and it's dated the 13th of May. And this indicates a forensic strategy meeting. So decision 28. And here we are, forensic strategy meeting. And there was a meeting held with relevant forensic specialists to prioritise the examination of items seized for forensic examination. And you've actually attached, as we move on a page, attached minutes from that forensic strategy meeting, which took place on Tuesday the 12th of May.
Yes.
So that was the previous day, and we've heard that both you and Mr. Little were present at that meeting.
And obviously, again, this is retrospective because I'm through in Howden Hall in Edinburgh chairing that meeting. So as we next day, that's when I record it, because the minutes would also get produced, and therefore I'm attaching the minutes so you can see exactly what was discussed.
Right. And then can we look at those minutes, please? And look at section 5, which says forensic examination priorities. Do you see that there on page 2?
Yes.
And then can we look at section 4, which is on the next page? And this is about PC Nicole Short's body armour to be examined for a possible footprint.
Yes.
We've heard witnesses talk of that as her vest. Is that's the same as the body armour?
Yeah, but it's the yellow vest that goes over the body armour.
Any footprint found to be compared with deceased's footwear, so Mr. Bio's footwear,
Yes.
which was seized at Victoria Royal Infirmary at the time of recovery of the body. And so it appears that both the left and right boot and Nicole Short's vest, as it says there, are being compared to look at a possible footprint.
Yes.
Now, you'll remember I spoke to Mr. Little about this and asked about the nature of the conversation that took place with the forensic experts in
Yes.
relation to that. And we're aware that, and Mr. Little appeared to be aware that sometimes it's very important to identify what tests need to be done, and the sequence or the order of those tests can be quite a significant matter.
Yes.
Because we've heard that some tests, such as fingerprint testing, can involve the use of black powder, which can actually have a detrimental impact on the ability of scientists to carry out subsequent tests.
Yes.
It can fall into the weave of material.
And it's frequently, because when you hold forensic strategy meetings, which I've done in the past, you've got the various experts, and you want them to advise you how, in their opinion, we should prioritise, because some of the testing can be destructive, as we've said. And what are we looking for? If you take, for example, the knife found, primarily we wanted initially DNA and not fingerprints, because if you go for fingerprints, it can destroy or affect DNA. So once the DNA analysis is done, then you move towards fingerprints, and really what you're doing is trying to decide in what order do these things occur. And the experts advise you, because these are forensic scientists, they have expertise. I'm not a forensic scientist, quite obviously. So a lot of times you're being advised by these experts, forensic experts.
So PIRC are very much reliant on the forensic experts to advise about order and potential implications.
Yeah, and it's still a decision for the senior investigator as to who does what, when, and in what order.
And you were the senior investigator at that time.
Yes.
But equally, the experts, the forensic scientists, will need input from you about what you're looking for in the investigation.
Yes.
And we've heard evidence from the forensic scientists about the tests which were carried out. And we've heard that fingerprint testing was carried out in relation to the vest. And I'm wondering, to what extent was there a discussion at that meeting with you about the need for fingerprint testing?
I don't recall the discussion at the time in relation to fingerprinting of the vest. And I'm operating off memory now, but I don't really see the significance of fingerprinting the vest, because I think we had been informed by that stage, although we didn't have the detail, that PC shot had been punched, and there was a suggestion that she had been stamped on, and that's why I'm wanting the comparison between the vest, the mark on the vest, and the footwear of Mr. Byle. Now this is mark comparison. If you want additional examination, and I know the inquiry went through that process where you go external to the SPA forensic scientist, you went to a bit expert in soil samples. But that's you again extending it beyond what the capabilities are within SPA forensics in some instance.
If I can stop you there, in fairness to you, I want to be clear about what you did know at this stage. So this is the 12th of May.
Yes.
You've not got the officer's statements.
Correct.
Did you have knowledge on the 12th of May about punching or stamping at that stage?
Yes. So if we look at punching initially, Police Scotland had recorded that on the day that she was assaulted. Kevin Nelson had said that he had seen Mr. Byle throw 2 or 3 punches. He didn't know how many connected, at least one connected. He saw her being propelled forward onto the ground. And there had been the suggestion of a stamp. Now, I can't recall now where that came from, but we were certainly aware of it, otherwise I wouldn't have asked for this.
You were aware of that on the 12th of May?
Yes, which is why I'm asking for this, so obviously I am aware.
And thinking back now, can you tell us when you became aware of the alleged stamp?
No, but obviously...
Because you don't have the police officer's statement.
That's correct. It's obviously come from somewhere. I can't recall now where it has come from, but we obviously were aware of it and it had come from somewhere, otherwise I wouldn't have asked for this mark examination.
Right. And you say it had come from somewhere. You may not know the source, but do you remember, was it a statement or information shared by email or a conversation that you had with someone?
I can't remember the source. I'm sorry, I just can't remember, but I was aware of it. Now, I don't know where that came from, but I was aware of it.
Is there anything in your log or any documentation that would help us work out when you became aware that there had been an alleged stamp?
No, I don't think so. But as I say, I was obviously aware, otherwise I wouldn't have asked for this examination at the forensic strategy meeting.
So asking for a comparison between the boots and the vest, that allows you to recollect that you were aware that there'd been an alleged
and what we're
stamp.
asking for there is mark comparison. So you would, they would photograph the mark, they would take imprints from Mr. Byle's boots, and they would compare those marks to see whether there was a potential match.
Is it possible that you were aware of a mark on the vest, and that was enough to ask for the comparison, or rather than a mark and an alleged stamp?
No, I think it would definitely be the alleged stamp. Police officers' vests have got all sorts of marks on them. So you wouldn't necessarily say, well, I want you to examine just any mark, you know. There had to be this suggestion of a stamp for me to specifically request this.
All right, so, but fingerprinting, not necessary. Fingerprint testing, not necessary.
I don't think so.
And DNA testing, what was your view on that?
Well, I don't think so. I think there was a term used in relation to the DNA examination of the knives, where it was, I can't remember, you might recall, but it was almost like was a collection of DNA and it could have come from various sources. Plus the fact, let's remember that police officers are dealing with people all day, every day when they're on duty, so you're going to get all sorts of DNA. Is it going to add any value to the investigation? I don't think so.
So the primary interest of PIRC in terms of the investigation related to the comparison of the mark with the footwear.
In respect of PC Short,
Was there any discussion about the forensic experts avoiding doing any other testing, avoiding fingerprint testing, since it wasn't of interest to PIRC?
not that I recall now. My priority, I think, in relation to this specific issue was the mark comparison, because that would have confirmed what we had been informed of. If you got an exact match, a lot of times you can never get an exact match, but it would have confirmed aspects of that because we didn't have the officers' accounts.
We've heard evidence from Professor Lorna Dawson, who was the expert in soil.
Yes.
And when she was sent items for comparison, she said, I asked her if her job would have been easier if the vest hadn't been stained with fingerprint powder. And she said, yes, absolutely. And we also heard evidence from Paul Ryder from a company called Cellmark. And he was asked about the impact of fingerprint testing on the vest in relation to the work he was doing about a comparison. And he said that the testing for fingerprints had caused dark coloured deposits on the fluorescent fabric and staining to the vest as a result. And because of that staining, it obscured parts of the dark staining that originally had been present on the vest. And so that made his job effectively harder.
Yes, I think at the time there was no consideration of going to such specialist experts as soil samples, Cellmark.
I'm interested in the issue of whether PIRC could have avoided fingerprint testing at all here.
Potentially, yes, because I would see no value in it.
Thank you.
Now, why that was done, I can't remember now, but I see no value in it.
Right. Can I ask you to look at an article that we've looked at before in relation to a very specific point? An article AAC 00379, page 7. It's an article that I asked Mr. Little about in evidence, and it was in the Herald on the 15th of May. So that's 3 days after the forensic meeting, strategy meeting.
Yes.
And there's a reference in that so this is AAC 00379, page 7. And there's a reference in this to a quotation from the then solicitor representing the officers who'd been at Hayfield Road. This is on a date you don't have statements from them. And there was mention of there having been an officer, a petite female officer, having been punched, kicked and stamped. You've explained the evidence you had about the punch. Here we are at page 7. Thank you. And you'll see not the left-hand column of the story, but the right hand there. If we go down below the element in bold, the quotation in bold, there's a reference to Peter Watson of PBW Law. And you'll see that it says in quotation marks, while it is deeply regrettable. Do you see that bit?
Yes.
That Mr. Bio lost his life, I would ask the media and public to remember that a petite female police officer was chased and then subjected to a violent and unprovoked attack by a very large man who punched, kicked and stamped on her. Do you see that?
Yes.
Now, that seems to be a reference there to a kick and a stamp.
Yes.
And this is prior to getting statements from the officers.
Yes.
I had suggested to Mr. Little in evidence that was perhaps the first time PIRC became aware, but you're convinced that you knew at the forensic strategy meeting about the kick
yes, I
or
think
the
so,
stamp?
because this is the 15th, whereas the forensic strategy meeting is on the 12th. So that's out of sequence. So the meeting was held before we were aware of this statement from Professor Watson.
So obviously Peter Watson was aware of this information. He provided that to the Herald. Does that help you when you're thinking back to how you knew about a kick or a stamp, so as to require forensic scientists to examine the boots compared to the vest? Does that help you recollect any contact or discussions you'd had with him?
With Professor Watson?
Yes.
No, I would not discuss such matters with Professor Watson, because that's sharing information with the Police Federation and their lawyer. And as I said in response to earlier questions, before we are putting such information or sharing it with anybody, we need to ask Crown's permission. Where Mr. Watson got that account, I don't know, but he was the lawyer acting for the officers.
Were you aware of this article in the Herald on the 15th of May?
I became aware that that statement had been issued.
We've heard evidence that there was a Federation press release and then there was this article in the Herald.
Yes.
Were you aware, they were not exactly mirror images, were you aware of this article in the Herald and the content of this article?
Now I can't recall. I was certainly reading everything, including all the media articles at the time. Can I recall this specific one? No, I can't. But I was reading everything.
So is it likely that, regardless of the position on the 12th, you've read this article at some point and noticed the references to punch, kick and stamp?
Yes. And as we know, this is not entirely accurate.
Sorry?
As we know, this statement is not entirely accurate because the allegation was a punch and a stamp, not a kick.
We've heard evidence about the matter now.
Yes.
Thank you. I'll move on to back to the log, if I may. And if we can move on to decision 29. There we are. Phone seizure and examination. There's a reference there. This is an entry dated the 13th of May. All mobile phones that may hold evidence relevant to the inquiry are to be seized and forensically examined for the period 2nd, 3rd May. Were you in possession of Ashley Wise's Snapchat footage from her mobile at that stage?
I think so, because she had offered up her phone to Police Scotland and agreed to have it examined for that specific information to be extracted. And also, as previously discussed, she then gave permission for PIRC to also extract that information.
When did you first see the Snapchat footage from Ashley Wise's mobile phone?
I think it was fairly early on. Because obviously the examination of the phone, I can't remember who did it, whether it was cybercrime within Police Scotland, or she simply forwarded some of those things. I can't remember the specifics, but it was fairly early on after we obtained that phone.
And there was an issue, as I understand it, in relation to the consent that had been provided by Ashley Wise, and I think you've been very careful in your answer that she'd given consent to extract the Snapchat footage of the incident in Hayfield Road. Did you have concerns about whether PIRC could investigate beyond that in her mobile phone?
we're now going into the complexities of what I would suggest is access to communications data, where you simply can't go on fishing expeditions and open up everything. It's got to be focused, and it's got to be targeted, for want of a better thing. So it would be entirely inappropriate for us to start reading her personal text messages, who she'd been phoning, all that sort of stuff, and that's why it becomes focused and targeted, and we're asking specifically, you videoed that interaction, we want that. We are certainly not going to go trawling about in the rest of your data. That would be entirely inappropriate.
We have an email in the inquiry between you and Mr. Little, where you instruct Mr. Little to examine all the material to determine whether it has a bearing, and if it has, produce it as evidence in relation to the mobile phone.
Yes, but again, that's, you're focused in on the time of the instant. So you're not trawling, you set parameters. You may have that discussion, you might not record what those parameters are, but we know that Ashley Wise, and she had given a statement, said, look, I videoed this on my phone. Great, but we want that material. But as I said, we're not going to go trawling around. Now, when it came to, for example, other phone examinations, you may extend those parameters dependent on the nature of what you're examining. So, for example, the precursor events, we know that Mr. Bayer was at Mr. Dick's house. He left there, went to Hayfield Road. So, for another phone, you might set that as your time parameter and not trawl through other data.
So when you were focusing on Ashley Wise's phone, was this in relation to quite a specific time period that you were interested in?
Yes.
And not just simply saying to Mr. Little, check the entire contents of the phone?
Absolutely not, because you've got the issue of collateral intrusion, which is a specific provision under the Act. So you simply can't go trawling around in a person's personal data. You've got to be specific to what material you're looking for, what time parameters you're setting, and extracting within those parameters data that may be relevant to the investigation.
Were you satisfied that Mr. Little had a clear impression of the precise data you were interested in?
I would think so.
When you refer to the Act, what Act are you referring to?
At that time, it was the RIPA 2000, or Regulation of Investigative Powers 2000. I think it's Section 2 of RIPA, where if you want to access communications data, you need authority, either from within the police. So you can obtain that communications data without the person's agreement. In some instances, an authorising officer, and I was an authorising officer, and I worked extensively within the field of interception of communications and communications data. But in relation to a person, if you're extracting data, you want that person's agreement. The other way you can achieve that is by seizing that phone as a production, at which point it becomes a Crown production, so in effect ownership transfers to Crown, then you can examine it. But again, you set parameters, you just simply don't go trawling through everything.
So, as I understand it, you had been, Ashley Wise had provided her mobile voluntarily.
Yes.
She consented to examination of her phone in relation to the events of Hayfield Road and the Snapchat footage that
Yes.
her consent did not go beyond that, however. And without her consent, you would have needed some further authority
Yes.
to explore more widely.
And I think we've also got to remember that if you take a person's mobile phone, if you seize it as a production, they're losing huge amounts of data on that. And it causes massive inconvenience. You know, we can think these days everybody's got, you know, complex mobile phones, if you take that away from a person, you're removing their access to a lot of information, a lot of data, all sorts of things, banking apps, whatever. It can have quite a detrimental effect on a person just seizing their mobile phone, and that's why sometimes it's better to obtain their consent to extract the relevant data.
Thank you. Can you explain, obviously, in your experience regarding Ashley Wise's phone, on what authority was the contents of her phone downloaded?
Well, she'd given permission.
Permission, as I understand it, about the events at Hayfield Road,
Yes.
and the Snapchat footage being
Yes.
downloaded.
But-
What about the contents of the phone being downloaded?
Part of the challenge, as I understand it, is that cybercrime, when they're doing a download, simply can't extract specific data. They do a complete download. We then filter that, ignoring the stuff that is not relevant, and get the data that we are looking for. But I think it's to do with the technicalities of how you download a phone. Cybercrime simply hit the download button and download everything, then extract the relevant data. It's more the technicalities.
So Police Scotland's cyber experts, if I
Yes.
can call them that, would download the entire contents of the phone. Would they sift out the relevant content regarding Hayfield Road on the 3rd of May, or would PIRC be doing that part?
They would provide it to us and we would do the sifting. Cybercrime is frequently overwhelmed, so they consider it as part of the investigative process for the investigation to do that. They simply do the download and hand you the data, the information.
And on what authority would PIRC then have to go through everything from the download, the contents of Miss Wise's phone, to extract the bit they want to look at for the investigation?
As I say, it's due to the technicalities of it. So you might get all this additional data, but you wouldn't examine it because you're looking for specifically what happened on the 3rd of May at the time. So you're looking surrounding there. You wouldn't go trawling through the rest of her data.
How would PIRC know what was relevant to the 3rd of May and the events in the morning without going through all the data that's provided by the
Because
cyber
the
experts?
download produces it in chronological order, in date and time order, so you know when the incident occurred. Therefore, you're looking specifically for around that time period.
So, and I appreciate PIRC don't have the technical ability to deal with this, but does that mean that in getting the entire contents of Ashley Wise's phone, that there was a question mark about the legal authority on which that would be held by PIRC?
No, because she's given an authority to examine her phone. Whether we'd said specifically, and I can't recall now, to allow us to extract the WhatsApps or whatever, I don't think she maybe understood that cybercrime would download everything, and then we would specifically look for what we described there. Because if she didn't consent to that, you could have seized the phone as a Crown production. If you seize the phone as a Crown production, then ownership technically transfers to Crown, at which point you could do that without the authority. Equally, if you want to do it without the knowledge of the person, that's when you're moving into RIPA, comms data arena.
And looking at decision number 29, there's no mention there of Ashley Wise's phone or any issues regarding Ashley Wise's phone, or any discussion between you and Mr. Little about the extent to which that's been examined. Would that decision not be recorded in the log?
Maybe I should have, but I didn't. I just took it as read that we were specifically examining the events, the incident scene and the precursor events leading up to it. And Miss Wise's phone was not the only phone that's seized in respect of this matter.
Right. Let's move on to decision 30.
In fact, could we move just quickly back up?
Of course, yes. To decision 29.
Yes, just scroll down to the bottom. Time parameters set so as to limit collateral intrusion, minimise impact on witnesses.
Yes. So this relates to phone seizure and examination and all mobile phones, and so type parameters set.
Yes.
But it's nothing there specifically about Ashley Wise.
So I don't within that set what those time parameters are, because each witness may be different and you're setting different time parameters. So this is more a general instruction, but I'm certainly saying we are going to set time parameters so as to limit collateral intrusion, and that minimises the impact on the witnesses, so we're not trawling through data that's not relevant.
Decision number 30. There's a note there, require 9 officers' personal details from Police Scotland. In light of refusal by officers to give statements at this stage, the personal details to be obtained. Why would you be seeking personal details of police officers?
Well, as police officers, when they submit statements to us, they will submit their full name, their date of birth, their age, their occupation, etc. So we didn't necessarily have that in respect of the 9 officers. We knew the names of the 9 officers, but we didn't have the additional information. So each officer has a scope record. I think you've heard evidence about that. It's where that information would be recorded, which is why we're asking for that.
And then if we can look at the reason, it says treat officers the same as any other witnesses. They will have statements taken from them at an appropriate stage, should their status remain as that of witnesses. Was there any question mark about the status of officers at this time? This is an entry from the 13th of May.
No, I was quite clear at that time, there were still witnesses.
Decision number 31. Seize officers' notebooks. This is again dated 13th of May. Why was this not done prior to this entry appearing in the log?
I think we were still working through things, so one of the things I consider the reason there was, did the officers make any entries in their notebook in respect of this incident? So go and seize their notebooks, examine them to see whether they created any entries, because we know that they hadn't provided statements, had refused to provide statements, hadn't completed the CS PAVA log or the use of force form. So what I was thinking there was there anything in their notebooks in respect of this incident that would assist in inform the investigation?
Decision number 32. This entry is progress interviews of relatives of the deceased to obtain background and medical information which may assist to establish a cause of death. I'm interested in this because yesterday you talked about not wanting to influence the pathologist's opinion. So can you explain why you were seeking this background and medical information?
Yes, because I think we sought GP medical records, and the GP medical records started at a particular date, and therefore we didn't have any information before that. Now, the best people to inform us may have been the family, because as we know, Mr. Baya was born in Sierra Leone and lived there for a number of years before moving to this country. Therefore, had anything happened, would his relatives be aware of any additional medical information that was not recorded in his GP medical notes, in order to provide that information to the pathologists.
Thank you. So by the 13th of May, you still didn't have the final post-mortem report it is.
That's right. I think it was mid-June before we received it. But you're wanting to provide, because we didn't have the GP medical notes for the post-mortem examination, but we're obtaining them when we identify that they only start from a particular date and don't cover the earlier part of Mr. Bio's life. Who's best placed to provide us with some of that information? The family, quite obviously.
And then decision number 33, there's a decision to obtain precise details of all Police Scotland communications with the family of the deceased. And I think part of the reason is the family say Police Scotland provided various different accounts to them regarding the death. If we go down to the reason, please. And this is an entry from the 15th of May. Is there a reason why this wasn't progressed sooner? Because we've heard concerns were expressed by the family about the police providing different versions on the 3rd of May.
I can't remember why I didn't record it sooner. At the meeting with the family and Mr. Anwar on the 6th, they expressed extreme displeasure and dissatisfaction with the way they had been communicated with. They considered that there were various accounts given, some of which were inaccurate, so they were extremely displeased. Why I didn't record it in the log earlier, I can't say, but as it sprung to my mind, I've put it in so it's formally recorded. But I was certainly aware of that extreme dissatisfaction.
Thank you. Then decision 34, you've returned to a narrative entry regarding it is clear that Crown Office are providing information to Mr. Anwar, the family solicitor, regarding the investigation, post-mortem and other findings. Was this of concern to PIRC that the Crown Office were communicating direct with Mr. Anwar?
I would say so. I would say it's highly unusual. Normally, in any death investigation that I've been involved in, the information is provided by the flows to the family or their representative. And part of my concern here is I'm unsighted in what Crown are telling Mr. Anwar. We may be providing different information. As I've mentioned earlier this morning, you're not providing comprehensive information to any family. You're not given a chapter and verse on the progress of the investigation. And therefore, what that can lead to is a breakdown in trust where they're getting some information from Crown, they're getting some information for us. Does that information differ? Does that lead to a breakdown in trust in PIRC flows? So that was my specific concern.
And I understand that you mentioned here Director of Investigations, we understand that was Mr. Mitchell then spoke to the Crown about the issue.
Yes, so we were aware of what Crown, what information Crown were providing, because it can lead to a breakdown in trust if they think, well, Crown have told us X, Y, Z and you're only telling us X. Well, why are you only telling us X? Because all of a sudden we know different. So you can see where that can lead to that breakdown.
Thank you. I'd like to move on to decision 37, so if we can move through 35 and 36. And you've also included another letter to the High Commission. So we're moving on to 37. And again, this is a narrative. The entry is made on the 27th of May. Text message received by Flo Alistair Lewis on the 27th of May from Addie Johnson, brother-in-law of deceased. See attached. And you include a copy of the email at the back of this page. And you say PIRC will not respond via text or email, but will provide relevant updates via flows to Mr. Anwar and family. Can you explain why, if the family wish to communicate with PIRC via text or email, why would there be concerns about responding to them using that method?
Because we're providing definitive information which is maybe contained in a text or an email. The normal method, in fact, the preferred method in all investigations is for the flows to deal direct and provide that information direct to the family, either through face-to-face meetings or through telephone calls. From memory, and we might come on to it, Mr. Johnson was asking for quite a lot of information, and as I've already discussed, the normal course you provide limited information. You know, he's demanding answers. Now, my job is to provide the evidence to Crown. As I've said earlier, section 44(6) of the 2006 Act, Crown's got to give me that permission to release the specific information, and I did not have that permission. And that's consequently why we're saying, look, you know, here's an email or whatever requesting voluminous information. We have no authority to release that information. We're quite happy for the flows to meet with the family face-to-face, to provide information to them, but we're not going to give them chapter and verse on the detail of an investigation, because that simply doesn't occur in any other investigation.
Was there any approach made by PIRC to the Crown to seek their authority to provide answers to the questions that were asked, or to give permission to communicate with the family direct through text or email?
No, because it's very much an operational decision as for us as the investigative body.
If the flow, Mr. Lewis, had requested you or Mr. Little to contact Crown to see if that could be an arrangement that was made, would you have been able to do that?
Yes, and we have previously done it, where we will approach Crown and said, we've been asked for this specific information. Usually we then provide a draft for Crown consideration. Now it's very much Crown consider that they say, no, you're not sharing that, or they can amend it, they can change it, or whatever, and then say, right, provide this information. But it's very much a Crown decision.
Right. Let's move on to decision there, to the next page. Decision.
Ms. Graham, it's just turned after 1 o'clock, so perhaps we'll stop here. We'll stop for lunch and sit at 2 o'clock.
Sorry, time flies.